Hello, hello. All right, we're gonna get started here, my friends. How's it going here today? What's going on? Anything exciting? Hello, hello. All right, we're gonna get started here, my friends. How's it going here today? What's going on? Anything exciting? Hello, hello. All right, we're gonna get started here, my
Ashley, I'm not sure where that's coming from. Hold on.
here. What's going on? Anything exciting? Hello, hello. All right, we're gonna get started.
I don't know why that keeps doing
Not
that.
sure where that's coming from. Hold on here. We're on anything exciting. Hello, hello. All right, we're gonna get started.
I don't know why that keeps doing
Not
that.
sure where that's coming from. Hold on here. We're on anything exciting. Hello, hello.
Are you there? Hey, Ashley, how's it going?
Hey, it's good. How's it going?
Pretty good, pretty good. What's going on? Anything exciting?
No, I'm almost done. I have like 4 more classes after this one.
Well, that's good.
Yeah, I'm gonna buy the Q bank this week, and I'm just studying. That's all.
So you're gonna buy the Q bank and you're gonna study. Now just so you know, you kind of get a good idea on things. Remember what you need to do, right? Is you will need to make sure that you do at least 110 questions, right? You're going to do at least 110 questions, and you're going to do those within 2 hours and 45 minutes, right? And then you're going to hold on, let me see something. All right. And then you're going to send me the screenshot. Make sense? Can you hear me?
Yeah, how long after my last class do I have to do that? Like, can I have a few days to study, or does it have to be like as soon as my last class?
No, you have as much time as you want,
Okay.
right? As much time as you want, you're able to make that happen.
Okay.
Just remember, you have to keep track of your 1 year deadline. All right. So keep track of your 1 year deadline. I don't know where you kind of stand on things. You just got to keep track on that.
No, I just started like in end of May. So
Yeah, I
I'm pretty.
apologize. I just forget.
Yeah, no, I'm trying to get it all done. But
Yep.
I just want to be able to like study and just go through a few more because like I said, I only have 4 classes left. So, but I want to
Yes.
study and be able to have a little more time before I submit the test or whatever.
Yeah. So you're doing fine, right? You're doing fine. You don't have to worry about it.
Hello, hello.
I'm not sure why that keeps doing
All
that.
right, we're gonna get started here, my friends.
Hold on.
How's it going here today? What's going on? Anything?
Let's see here. So yeah, so you're all set. Hey Ziomata, how are you, my friend? How's everything going? Good. All right. So any questions? Any questions that either of you ladies had or you wanted to go over or talk about?
Just where we are in the book today.
All right. So where we are is we left off on Saturday with leases. Right? We left off on Saturday with leases, types of leases. So I'm going to share that screen for you. Right? So here we are. Can you see that?
Yeah.
Hey, Kashana, how are you? Thanks for joining us. All right, so this is where we are, Unit 17 in the yellow book, right? We're talking about leases, types of leases, all that kind of good stuff. We're going to talk about all these different types of leases that we have here. Okay? And just remember, we have 2 different loops, right? So one of the loops is what? Monday evening Thursday evening, and Saturday morning. And then the other loop is Tuesday, Friday, Tuesday, Friday, Tuesday, Friday, so that you'll never miss a class. You just keep going back and forth, back and forth. Make sense? Any questions on that? All right. Let's see here. I'm trying to figure something out here. 1 second, my friends. All right. Well, let's keep on going. So any other questions? All right. All right, ladies. Well, let's get started then. So what we're going to talk about, different types of leases. Please stop me if you have any questions, you want to go over anything, right? The first kind of lease that we're going to talk about is a gross lease. Okay. Now, when we go over a gross lease, we're basically saying, okay, and this is what we usually see for residential, sometimes for commercial, but not all the time, right? Where the tenant just pays a fixed amount. And then maybe sometimes they might pay some or all of the utility expenses. So, like with a gross lease, they say, okay, the rent is, $1,500 a month, and you have to pay for your own heat, hot water, and electricity. And then the owner is going to pay for the water. The owner, the landlord, is going to pay for the taxes, or for the insurance, or for the property charges, or for the operating expenses. Does that make sense? Okay. Any questions on that? All right. So that's usually a gross lease. Now, again, that's what happens most of the time. But sometimes we also do that with commercial office leases, and that sort of thing. Okay. Sometimes if you were leasing out let's say a single family home, right? The landlord might tell you, hey, you need to pay all the expenses, right? Including trash collection, including water, including sewer fees, because you can do that, or the landlord can do that in the state of Connecticut if it's a single family home, or if there's meters for each particular unit, right? So sometimes we see that in condos too, but most of the time for like a 2-family house or a 3-family house, you usually don't see that, because they usually don't have a water bill or a water meter for each unit in like a 3-family house, right? And if you don't have its own separate water meter when it comes to residential, you're not supposed to be making people pay for those things. Make sense? Anyone have any questions? All right. Now, the next section, or the next type of lease, is a net lease.
Yeah.
Hello.
Mhm.
Right? So in a net lease, the tenant pays for all or most of the property expenses, right? And so sometimes people like to say triple net, right? You might hear that. This is usually for commercial leases. Oh, well, is it triple net? And what I always do is I always define it with them as what they mean, because I can promise you so many people have different definitions on what a triple net lease is and what a triple net lease isn't, right? So we like to get that in writing and make sure everybody understands. Okay, well, with a triple net lease, right, the tenant's going to pay all or most of the property expenses, some of the expenses such as hazard insurance, property taxes, CAM charges, in addition to the rent. Okay, and so a lot of times you'll see that if it's a commercial or industrial building and that sort of thing. All right. Percentage lease. So you could have a gross lease or a net lease, and it might be a percentage lease, where basically the rent is going to be based upon a minimum fixed rental fee plus a percentage of the gross income. So yes, you heard me right. You might be asking, wait a minute. So I have to give them, meaning the landlord, part of my income? Well, in this particular kind of lease, the answer would be yes, right? And so, like for example, I know someone that they did this kind of lease, and it was the kind of lease where it was actually at Eversource. I mean, oh my gosh, Evergreen, right? And in Evergreen, Evergreen's kind of like that place that they're going to advertise during the holidays for you, right? They're going to advertise during the holidays for you. They're going to work on trying to get people there, almost like a destination, right? So with that in mind, what they do is they say, okay, we want to be a partner with you, right? We want to be able to help grow this destination. And so because of that, because they're helping to grow the destination, well, what is it that they're doing? They're going to say, hey, um, we're going to give you a lower monthly or quarterly rate, but then you are going to have to pay a certain percentage of our of your income. So a lot of people kind of get scared about that, but I mean, it's kind of cool if you really do have a landlord that's willing to give you a break on things, right? And that's going to do some marketing, advertising for you to be there, right? Does that make sense? Who's got questions on a percentage lease? Anyone? All right. Well, let's go to the next one. Hold on one second, my friends. I'm just going to kind of get some information here. All right. All right. So we talked about gross lease. We talked about net lease, right? Where basically the lessee or the tenant is going to pay the basic rent plus all or most other property charges. And we talked about percentage lease. That's usually commercial, right? Where they're going to pay, meaning the lessee or the tenant's going to pay a basic rent plus a percentage of their gross sales. Okay. So that's percentage lease. There's also what's called a variable lease. Okay, so variable lease, there's a couple different kinds. One of them that they talk about is called a graduated lease, where they say, okay, over certain dates, over certain amounts of time, they're going to increase the rent. And again, if you're starting a new business, that might be something that you want, right? You might want to say, hey, listen, I want to start off slow. I want to lower rent right from the start. Okay. And so can you start me off lower right now? And can you start me off lower? And then in 6 months, when my business gets bigger, I will pay a higher rent. And then maybe in 6 months after that, I will pay a higher rent. Okay. So that's kind of how that works. So that's a graduated lease, right? Over a certain amount of time, right? And then we also have an index lease. And that's where the rent is increased or decreased periodically, maybe quarterly, maybe biannually or annually, depending on some changes in the consumer price index or some other indicator. I'll be straightforward with you. I've done so many leases, right? I've done gross lease, net lease, percentage lease, graduated lease. I've never seen anybody do an index lease, but I've never even heard of people doing it, but it's in your yellow book, so you need to know it, right? Any questions on that? All right. Let's see here. Hold on. Let's talk about ground lease. Okay, so we can talk about a ground lease. Now, when we talk about a ground lease, what we're basically talking about is, let's say, a landowner, they have unimproved land. Basically they have woods. They don't have anything built on it. And they lease it to a tenant who's going to erect a building on the land, and the lease is called a ground lease. So like a lot of, let's say, grocery stores, a lot of times they will do that. Not the ones that are in plazas, but like, for example, I know of the gentleman that owned the land over there in Rocky Hill. And then he owned the land, and then he did a ground lease with Big Y to build the big Y over there. Right. And so, basically there's separate ownership of the land, right? The land, and then of the building. So one party owns the land, the other party owns the building. And these leases are usually long leases. I mean, you're talking about usually like 99-year leases, because, no one wants to kind of build something and then be like, oh, I can't have that. I'm done for whatever number of years. Okay. So that might be something that, you might want to look into and learn about if you're into this whole thing about leases, is a ground lease. Okay. And so you might see that happen a lot when it comes to, Aldi's and Big Y and that sort of thing. I don't know if Aldi's buys their own land. But if you drive around some of these real commercial areas, you'll see ground lease, or sometimes you'll even see will build to suit, right? Where the owner will build the building. But anyways, ground leases are net leases. The lessee, right? Who's the lessee? Who's the lessee, my friends?
The tenant. The
Yep,
tenant.
that's right. So the tenant is usually the lessee. Okay? Tenant is the lessee. And usually they are the ones that are going to pay kind of all those extra fees and charges and all that sort of thing. Right? They're going to make sure that they're paying kind of the utilities, right? When it comes to ground leases. Anybody got any questions on those? All right. Next one, oil and gas lease. Of course, around here, let's say in Connecticut, right? We don't see that very much, oil and gas leases. But hey, it's a special lease agreement that people negotiate. That what we're talking about. What kind of rights are we talking about? What kind of rights are we talking about when we're talking about oil and gas? And it's important to make sure you know. All right, what kind of rights would we be talking about when we talk about oil and gas? Is it surface rights?
It's underground. I, I know what you're talking about, but I don't remember the word for it. But it's like the where the stuff underground, like the pipes and stuff like that, right?
Yeah. So what we're talking about, right, is subsurface rights. Right? That's usually what we're talking about, is subsurface rights. Okay? And so remember, you have air rights. Can you lease air rights? What do you think? Can you lease your air rights? Yeah, you can lease out the air rights. Can you lease out the surface rights that you have? Yes. And can you lease out your subsurface rights? Yes. So technically, if you bought land, right, you could lease out the air, you can lease out the surface, and you can lease out the subsurface to 3 different parties. Isn't that something? Who's got questions on that? Anybody? All right. Now, let's see here. Lease purchase. All right, so this one's kind of interesting. So a lease purchase is used when a tenant wants to purchase the property but is not yet able to do so. Okay? So what does the tenant do? Maybe the tenant can't get the mortgage, right? Maybe they're having problems, okay? So the terms of the sale are negotiated at the time that the lease is signed. Then the tenant will give the landlord a down payment that may or may not be refundable. And then every part of the rent is going to be applied to the purchase price of the property. Now, this is one of those things we always have tons of renters that, they just can't buy a house, or they think they can't get a mortgage right now, and they want to be able to do rent to own, lease to own, lease purchase. And I could tell you there's not a lot of landlords who are willing to do this. All right. It's really tough thing to do for landlords, because a lot of times, right, they usually have to kind of go back and tell the tenants, hey, what's going on? You're not paying the rent. And then they have to go through an eviction. And then when they go through an eviction, then what happens to that down payment? Okay, what happens to my down payment? And so they have a big time problem with that, not being exactly sure as to what to do with the down payment, how to handle the down payment. Even if it's written, people say, well, I put this amount of money into it already, and I did that, and I did this. So it turns out a lot of times to be a big time problem. Does that make sense? Anybody have any questions on that? Okay, so lease purchase, is that something that people do sometimes? But usually by the end of it, no one is happy. Oh, well, for example, you go through the first winter and the hot water heater breaks. And the tenant says, well, you need to fix the hot water heater. And the landlord says, well, you're doing a lease purchase, so you're supposed to take care of that. And then it becomes a big problem. All right. Sale and lease back. So in a sale and lease back, what happens? The property owners sell the property and then lease it back for an agreed upon period and rental. Okay. Then the original owners pull their equity out. And so basically they can use that money in order to expand their business. Right? So maybe, the grandfather started a furniture company. And when that grandfather started the furniture company, everything was great. And then his son took over, and the son liked to spend too much time on the beach. Right? And he wasn't paying enough attention to that business as the grandfather, because the grandfather built that business. And maybe the son not so much. And the years went by and the years went by. And now you got the grandson who says, hey, if we make, if we make this kind of chair or table, everyone's going to buy it and we can make so much more money. But they don't have any money and they have all old equipment. But maybe they're sitting on a piece of land and a building that's worth $5 million. So what do? They sell the property to get the $5 million. They sign a lease. I'm just going to make it up, $15,000 a month. They buy the equipment that's needed to make these awesome chairs. Now they can make a lot more money, right? And they can still keep the business going, even though they don't open up the land anymore. And it's still okay. I mean, even if they don't own the land, it's still all right. So who's got questions on that? Anyone? All right, let's keep on rolling. Right, so that was a sale and lease back. Let's talk about discharge of a lease. Okay, so when can a lease be discharged? Can anybody just say at any time, hey, I want to discharge this lease, I want out? Well, they could say it, but does either party have to let them out? Pretty much no, right? Because, I mean, when you sign a document, you know that you're responsible for what happens. Okay, so as with any contract, a lease is discharged when the contract terminates. Well, a termination can occur when both parties have fulfilled their agreement or when both parties agree to cancel the lease. So if the tenant, for instance, offers to surrender, right? They say, hey, listen, we don't want to be here anymore. We'll just give you the property back. And if the landlord accepts that tenant's offer, then yes, the lease can be terminated. But if a tenant, okay, just abandons the property, if they just abandon the property, they could remain liable for the terms of the lease. Okay. Now, most of the states that we know of, let's just pretend somebody will make it easy, where somebody rents out a property from January to December. And they pay in January, they pay in February, and then in March, they say, you know what? We don't want this property anymore. We're out of here. Well, it doesn't mean that automatically, right? We said March. It doesn't mean that automatically the landlord is owed the rent for April, May, June, July, August, September, October, November, December. It doesn't go by that it's automatic. You see, most states, the landlord has to make an attempt, right? Has to make an attempt to do what? What do they have to make an attempt to do? Anybody got an idea? What's your guess? Right? They have to make an attempt to do what? To re-rent the premises. They can't just sit around and wait and say, no, forget it. We're not going to re-rent it. We're just going to move on. Okay. Now, also, and this is an interesting one, people call me, I must get a phone call a week about somebody who says, oh, the landlord is selling the property, and so I have to move. And I say, well, do you have a signed lease? They say, yes. And I say, until when? And they say, February next year, February 2027. And I tell them, listen, the landlord cannot force you to move, right? Remember, leases go from owner to owner to owner. Now, if the lease expired, of course, that's one thing. right? That's different. If the lease, and he gives you a couple examples here. If the lease is from the owner of a life estate ends with the death of a person, yes. So if they say, hey, listen, you could live here for as long as this person is living, then yes, the lease might terminate. Or if it's a tenancy at will, which most of the time we don't have that, where the death of either party, then it gets terminated. But more often than not, what I find out is that they have to leave because they haven't been paying their rent. Right? So just know that if somebody calls you up once you get in this business and they're like, oh, I got to leave right away because you're selling the property. Well, do you have a signed lease? And then sometimes they don't have a signed lease. That's true too, right? Sometimes it's a monthly lease. And if it's month to month, then yes, the landlord could say, hey, you got 30 days, man. We want you to go. But I can promise you here in the state of Connecticut, and I'm sure in a lot of other states, it's going to be really, really hard for a landlord to move out that tenant, to get rid of that tenant. Make sense? All right. So remember, most of the time, the leases are going to go from owner to owner. In some leases, they do put a sale clause where the tenant has to be given a period of notice before the termination, right? But you usually don't see, this, just so you know, sale clause. You see how it's in italics? That means it could be on the state exam. And you usually hardly ever see that in a residential lease. Once in a great while, you might, but most of the time you don't. Okay. And that's when a new owner takes over the property. Now, a tenancy, though, could also be terminated by what? Operation of law. And operation of law, that means it might be a bankruptcy, it might be a foreclosure, it might be a condemnation. Okay. Now, let's say there's a breach of lease. Let's say the tenant breaches the lease. They violate the lease. How could a tenant violate the lease? What are some of the ways in which a tenant, right? What are some of the ways in which a tenant violates a lease or breaches a lease?
They don't pay their rent.
Right? Non-payment of rent. That's always a nice, easy one. Non-payment of rent. What else? How about something similar like criminal activity? Right? If there's conducting criminal activity. So those are really the easiest ones to try to, if you need to evict somebody. But even those are not easy when it comes to the courts. They don't make it easy. But also it could be health codes. Like there was one lady that she used to just throw garbage on the back porch. I mean, before you knew it, there was 2 feet of garbage on the back porch. And then every like 3-4 weeks, I'd have to go over there. I'd be giving her a hard time. I'd have to clean it up myself. And finally, I couldn't take it anymore. And I started the eviction on her. Right? I mean, believe me, it wasn't like she was an able person, right? She had a husband and he was an able person. They were like in their 30s, maybe 40s. They had a couple of teenage boys. Those boys could have took out the garbage, but they just chose not to. And I'll tell you one thing, I did get her evicted, but it took forever. Because the courts, they don't really help you out as much as you want them to in many cases as a landlord. All right. So anyways, though, let's say that the tenant breaches the lease. Okay, they breach the lease. Well, the landlord can regain possession through the legal process known as eviction, actual eviction. And what do they have to do? They have to, in most states, they have to serve notice on the tenant, right? And then usually there's a 10-day notice. And then it could be that they have a few more days in order to respond. And then finally, the court is going to tell, at least in Connecticut, they're going to tell you to go sit at the housing court and talk with a specialist and see if you can do mediation. And then ultimately, if the court believes that there is a problem, they will issue a judgment for possession to a landlord, and the tenant must vacate the property by a certain date. But believe me when I tell you, usually you're going to go to court 2, 3, 4 times, especially if you don't have a lawyer. Some of these tenants are really, really slick. They know how to go through each. They know the law better than, they could become a lawyer. Okay. Now, in some states, in cases of non-payment of rent, the landlord also has the right. This one's interesting. Okay. And this is called distrain. Nobody likes this. Distrain, Distrain. And what that means, distrain, is that basically they can seize the tenant's property, personal property, for rent in arrears. And then they could change the locks and give notice. And that's pursuing the remedy of distraint. Does that make sense? All right. All right. Now, let's talk about when a landlord, because not all these landlords are perfect, right? We know that. That's the truth, right? And some of them, they're supposed to be providing heat. They're supposed to providing hot water. They're supposed to provide a safe environment, a quiet environment, and sometimes that does not happen, right? So the landlord could breach a lease. And if that happens, the tenant has the right to sue and recover damages against the landlord. So if a landlord breaches, just like the other way around, right? What's good for the goose is good for the gander, right? So the tenant has the right to sue and recover damages. Now, if the leased premises become unusable for the purpose stated in the lease, the tenant may have the right to abandon them. So let's just say it gets really bad. Okay. The tenant can abandon the property, and then they have to prove that the premises have become unusable because of the conscious neglect of the landlord. And so to claim constructive eviction, right, the tenant has to leave the premises, right? And then they have to while everything's being fixed or whatever else. But I can promise you that the best thing for a tenant to do in this kind of case is to go to the housing court, because that way they won't have a problem with getting a bad record. Because once a tenant gets a bad record in the housing court, it's really hard to get rid of it. And a lot of landlords are going to want to stay away from that, right? A lot of landlords are going to want to stay away from that person when there's that problem. Okay, so does that make sense? All right. So, hold on one second. Hold on, wait a minute. All right. All right. Pro-tenant legislation. So we know for the most part, that's what we're talking about here, right? We're talking about pro-tenant legislation when I tell you that, hey, Leases are generally drawn up for the benefit of the landlord. But I don't know if that's always the case because, a lot of landlords, um, they're held just as much as the tenant, and a tenant doesn't want to have to move, right? So, I think it's kind of interesting as to kind of how they look at it, what's going on with it, and that sort of thing. All right, hold on a second. I got to update this. One second, my friends. All right. Very good. Very good. So let's see here. Where are we? We are at the wonderful world. We talked about pro tenants legislation. We talked about how this act, right, basically addresses issues like the landlord's right of reentry, the maintenance of the premises, the tenant's protection against retaliation, the disclosure of the property owner's name and address to the tenant, and specific remedies if they don't agree to things. So, that's kind of supposed to keep things more civil between between everybody. But I don't know how much help it's really, really done. Now, remember, there's a lot of federal and state, right, fair housing and civil rights laws. And those things are really important, right? Meaning that all people must have access to the housing of their choice, right? And there are protected classes, but at the same time, remember there's exemptions, okay? And if you don't know the exemptions, you should go back to your fair housing unit that we have spoken about in the past and to make sure that you understand what these exemptions are. But, basically we're talking about race, color, religion, national origin, sex, disability, or familial status. And you might be saying, oh, so they cannot um, tell me I can't live here because of my sex. Well, yeah, they can, right? Because if someone has a house and they're just renting out one of their open bedrooms and maybe they just want women or they want just men, they can do that because they live there. Does that make sense? But of course, race and color and national origin should never, ever, ever be a an exception. All right. Anybody have any questions on that? All right. So make sure that you understand violation of federal or fair housing laws are a big, big deal, and it could cost you a lot of money, right? Could get you in a lot of trouble. All right. So here's the key point review about leases. What is a lease? A contract between the lessor, right, who's the owner of the real estate, and also called the landlord, and the lessee, who's the tenant. Now, it transfers possession and use of the property. It lasts for a specific period and is made in return for consideration. What's consideration? When you see that on the state exam, what's consideration?
Is it payment?
Yeah, payment, money, right? Right? Just know that consideration is a reasonable payment or money. All right. Now, we also need to know about the statute of frauds. Statute of frauds, basically saying, okay, if it's a lease, basically it has to be in writing. If it's for more than 1 year, right? More than 1 year has to be in writing to be enforceable. Make sense? Anybody got questions on that? All right. And the lesser also has a reversionary right. So what's the reversionary right? Lesser has a reversionary right. What is that? What does that mean? Reversionary right. What's the reversionary right mean? Do, 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 do. Right? Basically, what they're telling you is that, hey, when the property, I'm gonna just stop sharing for one moment, right? When the property um has been done lease, when the lease is over, right? When the lease expires, the landlord can take possession back of the property. Does that make sense? They can take possession back of the property. Okay. Now, we didn't go over this tonight, but she went over it on Saturday, the different leasehold estates. So there's 4 different ones that you're going to have to kind of know in this unit that maybe you didn't go over before. Now, remember, I have videos on each one of these units. So, Ashley, do you know where the videos are?
On your YouTube or TikTok, right?
Yep, my YouTube
TikTok.
page.
Yep.
Yep. And then sometimes you see them on TikTok too, but you see the playlist for every single unit in the book. Ziomata, do you know where they are?
On your website?
Nope, on the YouTube page. Do you
YouTube?
know where
Oh,
you
okay.
know? Yeah. So do you know
But
where
it's all linked on your website, no? Don't
there
you
might
have
be a
videos?
link. There might be a link, but remember, so I'm going to show you all where these are because I want to make sure that you all feel comfortable, and Kashana, you too. All right, so let's see here. So I got to do stop share. Okay. What do I got to do? I got to do this. I got to open up. So remember, write this down. Okay, write this down. Oh, now I got to do reshare. So I got to do. Where are you guys here? Hold on. I'm having a hard time here. Are you guys there? Can you see my page or no? Okay, so what do you guys see? It says Zoom. What do you ladies see? I need you to help, my friends. You see
It says
Zoom?
Zoom. Yeah,
All
Zoom.
right. So in the URL, you're going to put smart, SMART, REadvice.com. So you see that? SmartREadvice.com. Okay? So that's going to bring you to to the YouTube page. And then in the middle here, do you see where it says playlists? Does everybody see where it says playlists in the middle here? Yes? No?
Yes, got
All
it.
right, thank you. And then I'm going to look for the playlist that says real estate. So it's on the left-hand side with the green with that purple guy. says real estate pre-licensing classes. So I click on that.
This is a very important.
All right, so that's on agency. All right, so I click on that. Now, man, that was only for a few years. That was only like 3-4 years ago. My beard is less gray. Man, it's getting bad. It's getting bad, Kashana. All right. But if I go over here on the right-hand side, just as an example, we're going to look for leases. Now, hopefully we're going to find it. Sometimes for some reason, I can't find things so easily. Appraisal, leasing part 1, leasing part 2. So I actually did 2 videos, one for an hour and 39 minutes, leasing part 1, right? One for an hour and 9 minutes, leasing part 2. So just know that everything we go over right here, okay, you're going to see that. Okay, so if you're like, well, you know what? He went kind of fast in class, right? So I did not get when he was talking about, because I'm going to go over this stuff now. What do you see right now, my friends?
The page, the book,
The
leaseholder.
book, good. Yeah. So I'm going to go over these 4 different types of leasehold estates, and you might later tonight be like, I don't know what he even went through. He just went through it so fast. I didn't get it. Well, you got those videos. You can watch them all the time if you want to. As long as you want, as many times as you want, you have all those videos there. All right. So, here we are, leasehold estate, key point review. What we're going to talk about is the lessee, right? During a leasehold estate, the lessee can be one of the following. The lessee can be one of the following. And here's the first one: an estate for years. These get a little bit tricky. Okay. So estate for years means it's a definite period. So like I said, January 1st to December 31st, right? That's a definite period, January 1st to December 31st. So that's an estate tenancy for years. Or it could be, how about this one? We had someone lease out a space in downtown Hartford. They wanted to do some big photo shoot, and they just wanted the space from 10 a.m. to 4 p.m. One day, 10 a.m. to 4 p.m., that would be called an estate for years or tenancy for years. And you might be like, what do you mean? Why is it for years? It's only for 6 hours. Because an estate for years or tenancy for years is for a definite period, right? So does that make sense? Now, let's just say you rent it out to somebody for 3 months. They say they only need it for May, June, or July. And they were supposed to move out July 31st. And here they are. It's August 3rd. And they're still in the property. Okay. So that could be considered an issue because maybe you were going to have your mother come and move in to that unit. So that is what's called a holdover tenancy. So you see what I have in blue, right? A holdover tenancy, when the tenant stays in the property after the lease expires and the landlord is still taking a rental payment, right? That's considered a holdover. So that's a estate for years or tenancy for years. Does anybody have any questions? All right. Now, let's just say you rent out, we're going to use Connecticut, right? Just because it's easier. And that's because of the ones that I know the laws for, most of them anyways, even though I'm not a lawyer and I don't play a lawyer on TV either. Okay. Anyways, let's just say that you move into a place and you don't have a lease. Yeah, like the landlord never gave me a lease. I don't have a lease. I can do whatever I want. Well, no, you can't, because the default, right? The default for the state of Connecticut is month to month. Okay. And month to month, 30 days notice for everything is a exact or a great example of an estate from period to period, where there's no exact specific expiration date, but there's intervals. And the lease term has continuity because it automatically renews. So a month to month is a common form, or it could be week to week. Okay. Or it could be year to year. But usually they don't do that. But if somebody has a month to month or a week to week lease, that's called an estate from period to period or periodic tenancy. Does that make sense? Anybody have any questions on that? All right. So those are the two main ones. After that, it starts getting a little bit tricky. Okay? Because the next one is a weird one, which we really don't go by that because, again, if you don't have if you don't have a lease, it goes from month to month in the state of Connecticut. But there is one, especially in other states, they might use it, called estate at will or tenancy at will. There's no specific term, and it's created by express or agreement or operation of law and can be terminated at any time. So let's just say the uncle says, hey, you can live here as long as you want. I don't care. Whenever you want to leave, leave. Or, hey, I'll let you stay for a while, but when I need you to go, you got to go. And then, if they don't give you enough notice, what are you going to say? Oh, you got to give me 30 days notice. Da, 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 da. And they might say, no, we have a tenancy at will. I told you that when I tell you got to go, you got to go. And you might be like, well, I need 60 days. Nope, I'll give you 30 days. I'll give you 20 days. And that's when it starts to be a problem. That's why the state of Connecticut says, okay, we're going to do everything month to month. Does that make sense? All right. And then the next one is called an estate at sufferance, right? An estate at sufferance. Tenancy at sufferance. And what's that? Well, that is created when the tenant stays on without the landlord's consent after termination, right? And basically, now they're not accepting the rent, and they're almost treating the tenant as a trespasser, right? And they say, hey, listen, you know what? We had a deal that you were going to leave on this date. I told you I needed you to leave on this date. You're staying here longer. You're holding over the apartment. And so now I need to begin eviction proceedings. Does that make sense? All right. So those are the four that you need to know about, right? For a leasehold tenancy. You need to know about an estate for years. You need to know about an estate from period to period, periodic tenancy. You need to know about an estate at will or tenancy at will. And you need to know about an estate at sufferance or tenancy at sufferance. So who's got any questions on that? Anyone? All right. Let's talk about a valid lease. So what are the main parts of a valid lease? Well, there's your thing called cloak, right? CLOAC, capacity to contract. What's that mean, capacity to contract? Anybody know? What's capacity to contract?
You're able to have a contract together.
Yeah, you're of legal age. You have the mental capacity, right? And then the L is for legal objective, right? It's a legal lease, right? And then offer and acceptance, and then valid consideration. Okay. So a lease usually includes a description of the leased premises, has an implied covenant of quiet enjoyment, has a non-disturbance clause. Well, what's that? Non-disturbance clause is a mortgage clause stating that the mortgagee, who's the mortgagee? Who's the mortgagee?
The mortgagee is the person getting the mortgage.
Is it? Who's getting the mortgage then? Be careful because who gives the mortgage?
The banks.
Nope. The bank gives the money, right? So remember, the bank gives the money. Who gives the mortgage? What's another word that I want everyone to remember for mortgage? Promise, right? Promise to repay. So the borrower or the buyer is the giver of the mortgage. They are giving their promise. They're saying, hey, bank, because you're not going to the bank to get a mortgage. You're going to the bank to get the money, right? So you say, hey, bank, if you give me this money, I will give you this mortgage. I will give you this promise to repay. So the mortgagor is the borrower, right? The mortgagor is the borrower. The mortgagee is usually the lender. Well, not usually, it is. So what this says is that the lender will not terminate the tenancies of the lessees in the event that the mortgagee forecloses, right? The lender forecloses on the mortgagor's lessor's building. So even if someone forecloses on a property, they cannot terminate your lease. Isn't that interesting? Right? They cannot terminate your lease. Does that make sense? Who's got questions on that?
Can you clarify that for me? Because I think I'm interpreting that as if a foreclosure happens, they still owe the debt from the contract for the mortgage that they still have to pay once everything is resolved. Am I misunderstanding?
Yeah, well, that's what I think you're going into is a different type of scenario where we talk about what happens with a lender and a borrower. In this whole thing, we're talking about the non-disturbance clause, right? Where it's saying that in the mortgage, it will even say that if the lender, the mortgagee, forecloses on the mortgagor's building, they cannot terminate the leases, right? And that's kind of, I don't know, I can't sit here and say it's a federal law, but guess what? I'm 90 something percent, 90 something percent sure it's a federal law. Banks are not going to be able, the leases always transfer from owner to owner unless both parties had agreed differently. Does that make sense? So once again, what do I usually find out when someone says, "Oh, well, my landlord got foreclosed on, that's why I have to move." They're telling me I have to move. I usually find out, "Oh, it's because you weren't paying the rent." Right? So it's kind of interesting. Hate to be so blunt like that, but that's a lot of times what it is. All right. Um, let's see here. Hold on. Let's take a quick one little break. All right. All right. So that is the non-disturbance clause. Okay. Important to know. Security deposit. I'm pretty sure you're all familiar with that. Well, what's a security deposit? A payment made by a tenant held by the landlord during the lease term And basically, if there's default or there's destruction of the premises, then they get the chance to use that money. Otherwise, they should not use it. That would be called commingling or conversion, and that'd be a big time problem. Okay. Improvements. Well, what are improvements? Improvements are usually, any structure, anything, a building, a fence, a driveway, anything that was built to add benefit to the land. Okay. Fixtures. What are fixtures? All right. What are fixtures? Fixtures are items of personal property that can be converted to real property by being permanently attached. So, unless something has been installed, usually the tenant can take it back with them, right? If it's a removable trade fixture, like a trade fixture, like let's just say you lease out a space to put a bakery and you put in some shelves, some showcases, you put in an oven and you wheel it in type of thing. Well, those are trade fixtures and those can be removed up until the last day, including the last day of the lease. After that, if you don't remove those, well, what happens? Who do they become property of? Right? Who owns those?
The landlord.
Yep, the landlord. Okay. We got the Americans with Disabilities Act requires that commercial, non-residential property be free of barriers or that reasonable accommodations have to be provided, right? Typical lease, well, not all the time, but a lot of times the landlord's going to be responsible for the maintenance. Okay. But it could happen that it's something else where the tenant's responsible. Most of the time, the lease is not going to be able to be assigned to somebody else. Sometimes it can, right? If it's a sublease, right, that has to be written in there. Sublease is like somebody's going to lease it out and then lease it back out. Let's just pretend I'm going to lease this property from you for $8 a square foot. And then I'm going to clean it up. I'm going to paint it. And I have really good property management skills. So I'm going to, then with your permission, I'm going to rent it out for $12 a square foot. And it's less work for you. And it's a little bit of work for me. And we both make money. Right? Recording of a lease. So sometimes that's required by state law, and we're going to go over the state laws in Connecticut right now about what that means to be recording of lease, because basically what they're going to say in your red book is that if it's been more than a year, then you should be recording the lease. Okay. And options, we have options that give the tenant the right to renew the lease, the right to purchase the lease property, or the right of first refusal if the landlord decides to sell the property. Okay. We have gross lease, requires the tenant to pay rent. We talked about that. And then the landlord pays all the other expenses. We have a net lease, percentage lease, graduated lease, ground lease. We talked about all those. And we talked about construction eviction. All right. Anybody got any questions on any of these? All right. So what I'm going to do is we're going to go back here. Right. And we're going to go into the Connecticut principles and practices. Okay. And we're going to go to leases, which is unit 12. All right. And let's talk about leases, my friends. All right. Now, remember, this is specifically Connecticut principles and practices. Okay. And we talk about Connecticut, we have the different steps involved. We have the Fair Rent Commission. We have registration requirements for absentee landlords. We have ejection, escrow account, essential services, eviction. leasehold estate, month to month, notice of lease. Okay. Now, Connecticut has comprehensive statutory laws. What does that mean? These are laws that they have been actually passed in a court, right? I'm not in a court. Oh my gosh. In a statutory, in a governing body. So what we're usually talking about is state legislature, like, with the state representatives and the state senate. That's what statutory laws mean. Like if you look at Connecticut general statutes, and they say that the statutory law, right, can be found under Title 47A of the Connecticut General Statutes entitled Landlord and Tenant. Make sense? Right? So Connecticut General Statutes. All right. So here we go. In Connecticut, okay, leases for more than 1 year, what do they have to be? They have to be in writing to be enforceable in a court of law. Otherwise, they're not going to be able to be enforceable. Make sense? Okay. All contracts for greater than $500 have to be in writing. Okay. Leases for more than 1 year have to be recorded. So leases for more than 1 year have to be recorded in the land records. Make sense? Right? Give constructive notice to a third party. All right. Alternatively, a notice of lease may be recorded in lieu of the lease itself. So you could have a notice of lease that's going to be recorded. Okay. And so all this has to have the pertinent information, like the names and the addresses of the parties to the lease term, right? A description of the properties, right? Has to be a notice of any right of extension or renewal. The date by which an option to purchase must be exercised, and reference to the place where the lease is kept on file. Okay. So remember, a lease is a tool to create a harmonious relationship between a landlord and a tenant. That's what it's supposed to be. It's supposed to make sure that there's no questions. There's no ambiguity. Everybody knows what we're talking about. Make sense? Who's got questions on that? All right. Leasehold estates. So Connecticut recognizes a term lease, all right, like we said, for a specific period of time, right? So you say from January to March, or from April to November, or from 9 a.m. to 5 p.m. Or Connecticut recognizes a periodic lease. So periodic lease is from period to period. If a tenant holds over after the expiration of his or her lease, the law construes the tenancy as a month-to-month occupancy and not an agreement for further lease. In all cases where tenancy is not subject, or there's no agreed upon term, or there's no expiration date, what do we have? What's the default in Connecticut? You remember? What's the default in Connecticut?
Is it a month to month?
You got it, right? So month-to-month tenancy is the basic. All right. Now, there is a Landlord and Tenant Act, okay, in Connecticut. And there's a thing called summary process for evictions. And this relates primarily to residential dwelling units. And so we're talking about residential. When it comes to commercial, there's all kinds of extra stuff. There's nothing we can do about it. Okay. So lease provisions. Basically they're going to say, okay, the lease cannot have these prohibited clauses. So like, for example, they cannot agree to waive his or her legal rights under the Connecticut general statutes. So like the landlord can't put in there something that says, oh, you're agreeing to waive these particular rights. Okay. The prohibited clauses allows the landlord to automatically obtain a judgment in court against the tenant without the tenant's knowledge. That's prohibited. All right. Agrees to excuse the landlord from any damages that the tenant suffers that would normally be the legal responsibility of the landlord. That's a prohibited clause. Right? Another one, agreeing to waive his or her right to interest on the security deposit. So a landlord just can't put that in there. They cannot put in there that they can evict or dispose the tenant without court order. They consent to the seizure of property as a security for rent. Agrees to pay the landlord's attorney's fee in excess of 15% of any judgment against the tenant in the event that the landlord bring the tenant to court. And so all those are not enforceable, and they're prohibited clauses. Make sense? You have any questions on that? All right. When it comes to security deposits, what's the story? Well, a landlord is not required to charge a security deposit. All right. But the maximum they can do is 2 months rent. As long as the person is not 62 years old or older. In the case of 62 years old or older, the landlord can require 1 month's rent. And if they're turning 62, right, after having paid greater than 1 month's rent, they can request a return of the excess. Make sense? All right. Security deposits, they must be kept in an escrow account and separate from the other funds of the landlord. The escrow account must be maintained in a financial institution. And remember, the banking commission, they have enforcement powers over this portion of the Landlord and Tenant Act. The landlord must pay the tenant the earned interest on the deposit at the anniversary of the lease. And the penalty for not doing so is a fine, $100. A landlord who knowingly and willfully neglects to return the security deposit to the tenant on termination of the lease will be fined $250 unless there is evidence that the landlord was entitled to the funds for damages created by the tenant. And a fine of up to $500 and or 30 days in prison can be levied on a landlord who does not hold the security deposit in escrow. Isn't that crazy? All right. So they got to make sure they're doing the right thing. All right. Now, who gets the interest? Anybody know? The tenants, right? When it comes to residential, the interest is payable on a floating rate tied to the average of national savings deposits. And basically, this rate is published by the Commissioner of Banking. And basically, the interest is supposed to be paid on the anniversary of the lease. to the tenant or subtracted from the next monthly payment at the option of the lessor. So who's the lessor?
The landlord.
Yep, very good. Now, if any rental payment is received later than the 10 days after the scheduled due date, the tenant will forfeit the interest for the month he or she is late in making the rental payment. And if the lease or rental agreement is terminated prior to the anniversary, the lessor has required to pay interest up to a date within 30 days of actual termination. When does the landlord have to return the security deposit back? Within how many days?
30.
You got it, within 30 days. And basically, if there's a problem, they have to give them like a written notice of the damages, right? And the tenant, if they don't do that within 30 days, then, and they don't give them like a written notice of the damages and what's going on and why they're holding back the money, then the tenant can recover up to twice the security deposit due to the tenant. And there might be a $250 penalty. All right. The landlord can adopt rules and regulations regarding a tenant's use and occupancy of the property, right? And so some of these rules and regulations might be like promoting the convenience, safety, welfare of the tenants, equitably distribute services to all the tenants, protect the tenants, or protecting the property from abusive use, right? Making sure that they are treating all tenants equally and fairly, and that everything's understood by the tenants, and so forth. Oh my goodness, I don't know what's going on. 7:20 something hit, and I'm dying here. Got to have soda. All right. So just remember, they could have rules and regulations too. All right. Now, a landlord's right to enter apartment. How much notice do they have to give in the state of Connecticut? What do you think? How much notice do they have to give? Do 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 do.
Is it 24 hours?
Did you read that, or are you guessing?
I guessed it.
Right? But hey, better than nothing, right? So the whole point is people think 24 hours, 48 hours, 1 day, 2 days, 3 days. No, there is no exact date. It's basically that number one, the landlord has the right to enter the property to make inspections, repairs, alterations at reasonable times, and they should be giving the tenant reasonable notice, right? Well, what's reasonable notice? I don't know. Is it 1 day? Is it 2 days? Okay. If it's the heat or something that's not working, I mean, reasonable notice might be like 15 minutes. I got to get the heat working. If the drain is clogged, hey, I got to come in now and unclog the drain. But if they're like, oh, I want to paint the living room or the hallway, maybe they say, hey, listen, I'm gonna come in 10 days. If they're going to put down a new floor, hey, I'm going to be there in 2 weeks, or I'm going to be there in 2 days, or I'm going to be there in 4 days. So there is no exact time period. It just have to be a big thing about making sure that there's no harassment. So does that understood? All right. Let's see here. Landlord and tenant obligations. So, what are the landlord's obligations? Well, landlords have to provide tenants with a written notice indicating the name and address of the manager, right? In lieu of such a notice, the person under the landlord's authorization entered lease and they have to be considered the manager, and there has to be legal process, okay? So it's the duty of the landlord to make sure that they're complying with all applicable laws and ordinances in his or her operation of the property, right? And they have a whole long list of things that you need to look at and that you have to think about. So, for example, they have to adhere to applicable building and housing codes. They have to keep the property in fit and habitable condition, unless the property is intentionally made unfit for occupancy by the tenant, his or her family, without the landlord's consent. They have to keep all common areas clean and safe. They have to maintain good and safe working conditions by all the equipment, like the appliances and the heating and the ventilating. They have to provide and maintain trash receptacles. Now, here's one that's interesting, right? They have to supplying heat, running water, and reasonable amounts of hot water at all times, unless the law does not require it or the unit occupied is constructed so that the tenant has direct public utility connection and controls those amenities. All right. So even if you're paying for heat, let's say in a 3-family property, they have to make sure that the boiler is working. They don't have to necessarily, well, of course you got to talk to a lawyer. They usually don't have to necessarily make sure that the natural gas is coming in, but they have to make sure that it's up and running, that the boiler works. Okay. So the landlord and the tenant, what are they going to do? They're making good faith written agreements that says, hey, we're trying to work together and, and that the agreement is in place, to make sure that everything's going to be working out. Now, if the landlord sells the property, now they're relieved of those agreements, right? And that notice goes to the new owners, and they are the ones that have to go by that lease. Okay. Managers of rental properties, they represent the landlord and are not personally liable for violations of rental agreements. So that's important to know. All right. Unlawful occupancy. So what is unlawful occupancy? It's issued by the local building inspectors and certified that a structure is habitable for the purposes intended. And if a landlord allows or permits a tenant to occupy a building that doesn't have a CO, right? If it doesn't have a certificate of occupancy, they are not supposed to be charging rent, and they can get in a lot of trouble for that, right? So, like as an example, let's just make pretend, that landlord, it's a 2-family house, but they're renting it as a 3-family. They're renting out either the attic or the basement, right? Well, they can get in a lot of trouble for that. And you can, God forbid somebody gets hurt or there's a problem where there's a fire, the insurance might not pay for that, right? So you have to make sure you're really careful and that what you're renting out, you can rent out. You have a certificate of occupancy for it. Make sense? Anybody any questions? Receipt of payment of rent. So landlord must provide a tenant with a receipt for a cash payment, even if no receipt is requested. All right. Tenant's obligations, my friends. So, in using the property, tenants are generally obligated to conduct themselves and to use the property in accordance with both state and local laws and ordinances and without infringing on the rights of others, particularly those occupying other portions of the same property. So, tenants are not supposed to bother other tenants. Pretty simple, right? Tenant has to comply with building, housing, fire codes. Keep his or her unit as clean and safe as the general condition of the premises. Remove all trash and rubbish to places and or receptacles. Keep all plumbing fixtures and appliances as clean as the condition of them. Use all equipment and appliances, not willfully destroy, damage, impair, or remove part of the property that they're not permitted to do so. They're not supposed to disturb their neighbors, and they're only supposed to occupy their unit. And if they're going to be away for a long time, they're supposed to let their landlord know. So those are pretty much the tenant obligations. Any questions on that? All right. Criminal damage. Gonna take a quick break here for 1 second. All right. Criminal damage. So a tenant who intentionally damages leased property, including damage to reckless action, is considered to have committed a crime and can be criminally prosecuted. If damage to the property exceeds $1,500, the crime is criminal damage to the landlord's property in the first degree, which is a Class D felony. If the damage exceeds $250, but is less than $1,500, the crime is criminal damage of a landlord's property in the second degree, which is a misdemeanor. So, like, tenants can get in big time problems for criminal damage to properties. All right. What's the recourse? So, landlord's recourse. If a tenant fails to pay rent within 9 days of the due date, the landlord may terminate the lease and evict the tenant under the procedures described later in this unit. Okay. With respect to breaches of the lease by the tenant that do not involve non-payment of rent, the landlord may deliver a written notice to the tenant citing the breaches and notifying the tenant that unless these breaches are remedied, the lease will terminate in 15 days. From there, the tenant has 15 days from the date of the notice to cure the breaches by repair or payment to the landlord. And then at the end of the 15 days, if the tenant takes no action to correct the breach, the lease is effectively terminated. So that's kind of interesting, right? What are the actions? So the landlord may initiate or maintain legal actions against the tenant in a variety of different circumstances. The landlord may maintain an action to recover possession of a dwelling unit under the eviction procedure. If the tenant is using the unit in an illegal manner or in a way that is prohibited by the lease agreement, if the tenant has not paid the rent, if the landlord is making a good faith attempt to recover possession to use the unit as his or her home, if the tenant's guests or family with his or her consent has willfully damaged the property, or if the landlord is seeking to recover possession after giving proper notice to terminate the tenant's periodic tenancy. All right. Ziomata and Kashana, you both have to be on camera. Please, be on camera as soon as possible.
I am on camera. You don't see me?
Oh,
Yeah, it's just my laptop. I had to leave. So I'm on my phone,
wait a
but I'm
minute.
here.
What?
Yeah,
Oh,
because I just signed in from my phone.
oh, all right, no problem.
But I
I
have my
understand.
laptop still on
Yeah,
at
I
home.
didn't see
Okay.
you.
That's
Because
okay.
then
That's
I
okay.
saw you
I'm
gone
here.
for a little bit. No problem. Very good.
Okay.
I'm sorry. I
That's
saw
okay.
you gone, and then I saw Kashana, and I'm like, wait a minute, you guys, we're gonna get in trouble, man. We gotta get you guys back on camera.
No, I think she put me right back on the thing.
Good. All right. Sorry about that. Okay. Now, there you go. You're back to Kashana. All right. So tenants protection against retaliatory action. So remember, the rent is determined by the rental agreement. But with a month-to-month tenancy, what can happen? Well, the landlord can raise the rent after giving the tenant 1 month's notice. But landlords cannot raise rent as a retaliatory action. So within 6 months after, so it will look like a retaliatory action if they try to raise the rent within 6 months after the tenant made a good faith attempt to legally remedy the landlord's violations, right? If the landlord have violations of his or her legal obligations, if there was any municipal agency or official filed a notice, order, complaint, if the tenant made a request in good faith that the landlord make needed repairs, or the tenant has organized or become a member of a tenants association or union. All right. So you can't do that if you're a landlord within 6 months, if it's going to seem retaliatory. All right.
So
Abandoned.
is it, oh,
Go ahead.
is it,
No.
so would it be considered not retaliatory if it's 7 months?
Yeah, I mean, they could do it.
It's
They
okay.
can wait the 7 months.
So, but for sure, 6 months that's like you have to wait
Yep.
that long. Okay.
Black and white. Yeah, you got to wait those 6 months. If, one of those four things,
Okay.
if one of those four things, like, let's just make pretend the landlord goes, I mean, oh my gosh, the landlord, let's make pretend the tenant went to the town housing authority to complain about the landlord, right? Now that landlord is going to have to wait at least 6 months to raise the rent, because otherwise it will be considered retaliatory. Man, that shadow is so weird. I don't know. Looks like I don't know what that is from. Probably from this. There we go. Weird shadow, right? All right. Abandonment. So, if a tenant abandons the property, right? The landlord is required to make a reasonable effort to rent the property. We talked about this a little bit, to re-rent the property. And they have to seek a fair market rent for it. And thus, if a tenant on a 12-month lease abandons the property after 3 months, the landlord cannot merely just sit back and allow the overdue rent to pile up under the assumption that he or she can eventually sue the abandoning tenant for the full amount. They have to make reasonable effort to rent the abandoned unit to keep the loss, the amount for which he or she should sue, to a minimum, to keep it for a minimum. Does that make sense? They can't just be like, oh, well, this person, they're going to owe me 9 months rent. So I'm just going to wait. I'm not going to even bother. I'm not going to have any, like, wear and tear on the property. No, they have to make reasonable efforts to re-rent the property. All right. Tenant's recourse. If the landlord, let's say the landlord breaches the property or breaches the rental agreement, fails to fulfill his or her legal obligations, the tenant may terminate the agreement and they have to give the landlord 15 days from the receipt of written notice of the acts or omissions that provoke the breach. And if the landlord doesn't take any action at the end of the 15-day period, then the lease can be terminated by the tenant. But like I say, I would tell you, make sure you go to the housing court. You do not want to have a problem. Okay? So, in the event that the same problem giving rise to a current breach has occurred within the previous 6 months, like let's say a leaking ceiling, the tenant can terminate the agreement on 14 days written notice, as long as the notice specifies the date on which the breach or the leak in this case occurred and the date on which the tenant intends to vacate. This must still be within 30 days of the breach. Note, however, that if the breach is the result of the tenant's or member of the tenant's family on the leased property willfully or negligently act, he or she may not terminate the agreement. So if it's something that they did to the property, then they can't just terminate it. Who has questions on that? All right. Now, we talked earlier in class about supplying essential services. Even if the landlord, I mean, even if the tenant is responsible to pay for, that particular that particular service, right? The landlord has to make sure that those things are supplied. So they have to supply essential services like heat, water, electricity. The tenant may provide the service at his or her own expense and then deduct this amount from the scheduled rental payment. So if, let's just make pretend, I don't know, the landlord's supposed to pay for the electricity and then they don't, or for oil and then they don't. Well, the tenant can go get their own oil and then deduct it from the rent. Or if it's a lack of those services, the tenant may procure substitute housing until the services are restored. But remember, the landlord has to be given at least 2 days to remedy that breach. Okay. They have to be given a chance to fix things. And if it's occurred within the previous 6 months, the 2-day period is eliminated and substitute housing may be procured immediately. You have any questions on this? There's a lot, right? There's a lot of little things that go along with this unit. But, sometimes, most of the time, if you just kind of think about the what's reasonable, what's logical, what makes the most sense, you should be okay. Do you have any questions on this? Got about 15, 20 more minutes to go, my friends. Isn't this exciting? All right. Let's talk about damage or destruction of the property. Okay. So if the property is damaged or destroyed so that the tenant can no longer occupy or use the property, right? And if it's result of the landlord's either willful act or negligent, then the tenant is not liable to pay rent. So I don't know if maybe there was a fire because the landlord did not use a licensed electrician, or whatever it might be. The tenant is not liable to pay rent. And once again, they can terminate the lease agreement within 15 days. And they're supposed to get that tenant is supposed to get back any rent that they paid and security deposits too. All right. So that's the important thing. Again, that tenant is going to want to file an action in court so that there's no problems in the long run. Otherwise, there could be some issues that come up. All right. summary process. That's the actual eviction process. Okay. So basically it's called the summary process, and it can get a little bit complex, right? If you can do it on your own, you could try to do it on your own, but if the property is owned by an LLC, you have to get a lawyer, you have to get an attorney, okay? And the first step is that the landlord will serve a notice to quit, right? And this is given by the landlord to the tenant. And usually again, it's like non-payment of rent or violation, something of the property. Maybe the person's using the property illegally, like maybe a betting parlor or whatever it might be. And so the landlord is going to give them a notice to quit possession. Okay. Now, if the landlord, oh my gosh, if the tenant does not leave after the time the notice to quit possession has passed, the landlord can file a complaint in Superior Court for immediate possession. If the tenant fails to appear in court, what do you think happens? The court will file a judgment and award the landlord possession and his or her costs. If the tenant appears in court, a lot of times they're going to have a hearing, and the court will order the tenant to deposit with the court an equal amount of fair market rental value of the property for the court proceeding period. And then they will make a determination. Usually what's going to happen is the landlord is going to serve the notice to quit. The tenant is going to have so much time period to get back. That's going to go to the housing court. A lot of times they might set up a mediation meeting. And if they can't resolve it, then it goes into the Superior Court. Okay. Now, if a tenant is making an appeal, tenants making appeals in an eviction action have to post a bond for all rents accrued and those that will become due during the appeal. If there's no lease in effect that identifies the rental amount, the bond will be based on a fair market rental value. So appeals must be made within 5 business days after a court judgment is rendered. As long as the court does not feel that the appeal is being made solely to delay execution, it will accept the application for appeal, and the execution of the eviction will be stayed or put off. So, if an appeal is made, then they hold up. That's why I say sometimes they got to go to court 4 or 5 times. So, unless the landlord is evicting the tenant for non-payment of rent, nuisance, the use of the property for immoral or illegal purposes, or no initial right to occupy the property, there will be a 5-day stay of execution. In addition to the stay of execution, a tenant may, upon application to the court, be granted additional time to vacate the premises if the court finds the reasons valid and acceptable. So, like, I know a lady, she's been going to court since March or April. I'd say March. So it's been 5 months. Every time she goes to court, she's the tenant. She says to the judge, I'm senior citizen and I can't find a place. And I'm sorry, but I've been looking. And the judge gives her another 30 days, 40 days. And, I understand because and I'm helping her try to find a place to live. And I told her, I said, listen, the judge is only going to give you so many chances. He's already given you like 3 chances. I don't know if he's going to give you another one. You don't find a place by September 15th. You're going to have a hard, situation to deal with. All right. Okay. Now, ejection and the removal and sale of personal effects. So finally, if there's an expiration, right, when the date on which the judgment is permitted, the tenant or occupant or defendant they have to remove themselves and all their belongings. If they don't, right, the landlord basically, well, they're going to have a state marshal that's going to go over there, and the marshal has to make a reasonable effort to locate the tenant, inform them of the action being taken, and the possibility of the sale of the belongings if they're not claimed within 15 days, and the storage expense will have to be paid by the tenant. If there's no claim made, the property is supposed to be sold at public auction. And once the sale has occurred, the tenant may claim the proceeds within 30 days. Got any questions on that? Let me ask you before I forget, did anybody come to class on Friday? Ashley? No. Kashana? No. Ziamata? No. All right. Because I need to find out what they did on Friday and put it in the new blog. All right. I was just thinking about that. All right. So are landlords the only ones that can bring actions of summary process? No. Assignees, mortgagees, they can do that too. Okay. Anybody who's owed money, they can bring actions of summary process to recover possession. Eviction of elderly or physically disabled, that's going to be pretty darn hard, like I told you, right? So, a person would have to really have a good reason and be able to stick with the courts in order to make that happen. Other leasing considerations, fair rent commission. Which I don't see that much in Connecticut. I thought they were going to put more of those in place, which I think they're, the newest books tell you that most towns now, they have to have a fair rent commission. Okay. Where that fair rent commission looks at what is fair market value, and then they handle complaints from any tenants and kind of discuss things. So that's something that's out there, right? And there's also even an absentee landlord registration. So when we talk about this absentee landlord registration, we're saying that, okay, if you're a landlord and that you don't live in that property, you are supposed to let the town know. You're supposed to have your address recorded. You're supposed to make sure that they know where the tax bill is to be sent. Of course, the town wants to make sure they know where the tax bill, and give them your phone number as well. All right. So that's the key point review for leases, right? What did we talk about here in Connecticut? Okay, specifically. A lease for a term 1 year or longer has to be in writing. A lease for more than 1 year has to be recorded in the local land records so that they can give constructive notice. Okay. The state recognizes two types, term leases and periodic leases. And if the tenant goes beyond their term, the tenancy then becomes a month-to-month tenancy. Okay. There are certain rights and responsibilities between landlords and tenants, and there's a summary process eviction that's right in place under Title 47A of the Connecticut General Statutes, and that there are some prohibited clauses that the landlords cannot put in leases. We talked about security deposits. According to the law, the landlords have to pay interest on the security deposits for residential units, right? So we talked about that. A landlord may adopt and enforce rules and regulations about the tenant's use and occupancy. What are they doing there? Are they just living there? Are they selling something from there? Are they doing a daycare center from there? The landlords have several obligations, like keeping the property in fit and a bit habitable condition, keeping common areas clean and safe, supplying heat, running water, reasonable amounts of hot water at all times, and the landlords always have to provide the tenants with a receipt for cash payment. All right. Now, what are tenants obligated to do? They're obligated to comply with the building, housing, and fire codes. They have to make sure they keep their unit and fixtures within clean, right? Anything that's within the property clean. They cannot impede the neighbor's peaceful enjoyment of the property. And tenants who intentionally damage leased property have done criminal damage to the property, which is considered to be a misdemeanor. All right. Now, landlord recourse. If a tenant fails to pay the rent within 9 days of the due date, well, what can happen? The landlord can terminate the lease and evict the tenant. But the tenants do have protection over what? Retaliatory action of the landlord. Okay, so we said, hey, the landlord cannot do certain items within 6 months of the tenant making a complaint, going to the housing court, the housing authority, going to the housing court. If the landlord tries to raise the rent within 6 months because from that time period, that's considered to be retaliatory, and they could have a problem with that. Okay. In some municipalities, where there's more than 5,000 units, which is most places now, there's a fair rent commission, and that absentee landlords must register their residential addresses with the city or town that houses those properties. So, and then you could see here, they give you all kinds of different web links. So if you want to learn the general statutes, right, of what's going on in Connecticut, if you want to know the Connecticut Department of Banking Security Deposit interest rate. So let's take a look at that. Like if we click on that, right? Well, here is the Department of Banking in the state of Connecticut, right? The rental security deposits. So landlords, once you give the key to the rental apartment, you have to follow these basic rules. Tenants, once you accept the key, you have to follow these guidelines. And so here are the guidelines, right? Security deposit remains the tenant's property, but the landlord holds it. Okay. How large? Cannot be more than 2 months, reduced to 1 month if a tenant is 62 years of age or older, right? Who pays the interest? Well, technically, right, the account pays it, and the interest rate is 0.49% annually. So if you have $1,000, how much is that going to be? Anybody know? Is it $49 or is it $4.90? Let's see here. Let me do my little calculator. Calculator says $1,000 times 0.49% equals 49 cents. So that's how much your interest you'll get. If it's $1,000 security deposit, you get 49 cents, my friends. All right. That's why you need to go buy a property instead of renting, right? We all know that kind of stuff. Well, some people, there's pluses and minuses. We all know that stuff. All right. So we got about another minute or two. Who has any questions about the units that we went over, about leasing and that sort of thing? Any questions, any things you wanted to go over or talk about? All right. All right, my friends. Well, remember where we're going to leave this is if we go into our yellow book. Let me go back to that. I think I got to do a little share here really quick. All right. If we go into our yellow book. Hey, Mike, thank you, my man. Best teacher in the world. Yeah, Mike was one of our students, and now he's on the team, and we're excited. Appreciate you, Mike. All right. So we are getting ready. We just did leases. If I go into the yellow book, right, we're going to do the next unit, which, and that's going to be Thursday night, right, which is Unit 18, Fair Housing. So just remember, Fair Housing is the next class for Thursday night. And then I'm going to have to look up and see what we got going on for tomorrow morning, and I'll put it in our blog. All right. Anybody got any questions? Thanks, Mike. I appreciate it, my friend. Well, thank you, everyone. I hope you have a good one, and we'll talk to you soon. Have a great night. Good.
Thank
You're
Good night.
welcome, my
Thanks.
friend.
Okay,
Thank
bye.
you. I appreciate you
Yeah.
being here. All right.